Anything else at 2 or just us?
Just us at 2. He has at 2:30.
Yeah. Anything else at 2 or
Just us at 2. He has at 2:30.
Yeah.
Hi, there's a number ending in 3336. Can you please state your name?
Jay Cards.
Hi, there's a number ending in 3336. Can you please state your name? Mr. Burns, were you planning to make a formal appearance?
Jay Cards.
Hi, there's a number
No,
ending
I'm
in
just
3336.
monitoring.
Can you please state your
Okay,
name? Mr. Burns, were you planning to make a formal appearance?
Jay Cards. No, I'm just monitoring.
Can you please state your name? Mr. Burns, were you planning to make a formal appearance?
Jay Cards. No, I'm just monitoring.
Okay, Mr. Burns, were you planning to make a formal appearance?
Jay Cards. No, I'm just monitoring.
Okay, Mr. Burns, were you planning to make a formal appearance?
No, I'm just monitoring.
Okay, Mr. Burns, were you planning to make a formal appearance?
No, I'm just
Still going in there.
No, I'm just
Still going in there.
All right, how are you?
Looks like you're moving around.
Yeah. Trying to. Yeah, good. 3 months out now. All right. Good.
Yeah, that's just a few.
Working with David Finn.
He's a good guy. I have a lot of travel with, so he's trying to partner with bigger firms right now. So left the U.S. Attorney's Office a while ago. What's that? Haven't met him. Yeah. Okay. I guess Megan is not here.
How you doing?
Hi, there's a number ending in 2200. Can you please state your name?
Yes, hi, my name is Michelle Obayen. I'm an attorney at Herman Law representing CVA survivors that have filed timely proof of claims in this case.
Did you want to make a formal appearance for today's hearing?
No, I'm just looking to monitor the case. Thank you.
Okay, thank you. We'll be starting shortly.
Ms. Olivia, are there any power plugs near any of these that I could plug into?
Here,
If not, it's fine. I'll.
Maybe you're.
It's all right. I'll wing it. It's fine. It's all good. Thank you.
All set, Your Honor. Thank you. All rise. Department 1 of the United States Bankruptcy Court, Southern District of California, is now in session. The Honorable Christopher B. Latham, Judge presiding. Please be seated and come to order.
Good afternoon. Welcome, everyone.
Good afternoon.
For our phone participants, I'd like to remind you to please not have your device on speaker function. Otherwise, it's very difficult to hear you clearly in the courtroom. And with that, please call both matters, Ms. Olivas.
Calling calendar items 19 and 20 in the matter of the Roman Catholic Bishop of San Diego. Motion for attorney's fees in connection with Zalkin claimants withdrawn. Motion to dismiss, followed by the Catholic Mutual Relief Society of America and Catholic Relief Insurance Company. And status conference on Chapter 11 petition continued from 9/8/25. May we have the in-court appearance by counsel for the debtor?
Good afternoon, Your Honor. Jeffrey Cadre, Gordon Reese, Scully Manzacani, appearing out on behalf of the RCBSD, debtor and debtor in possession.
Hello, Mr. Cadre.
Hello.
And may we have the in-court appearance by counsel for the Zalkin Law Firm PC?
Good afternoon, Your Honor. Devin Story for the Zalkin Law Firm.
Mr. Story, welcome.
Thank you.
May we have the in-court appearance by counsel for the OCC?
Good afternoon, Your Honor. Sam Kidder, KTBS Law, on behalf of the committee.
Hello, Mr. Kidder.
May we have the in-court appearance by counsel for the Roman Catholic Services Parishes and Schools?
Good afternoon, Your Honor. Paul Leeds and Shelby Petit for the Catholic Count for Parishes and Schools and for the parishes, schools, and the support corporations.
Good afternoon.
And may we have the in-court appearance by counsel for the Catholic Relief Insurance Company et al.?
Good afternoon, Your Honor. Christopher Wong of Aaron Fox. You have with Everett Seigel with me as well on behalf of Catholic Mutual.
Mr. Seigel, Mr. Wong. Good afternoon.
That concludes appearances, Your Honor.
All right, thank you. How I expect to proceed today is to cover the status conference and then go into the motion for attorney's fees. I don't expect to rule from the bench today, but I'll issue a written order at the end of argument. So with that, Mr. Cadre, if we could please have the latest, anything to add to the latest items on the docket or anything else you want to air today?
Thank you, Your Honor. We submitted our seventh Chapter 11 status report on September 2nd, 2025, and of course the court continued out the status hearing for today. The update we provided in the status report, the debtor remains current in its obligations to the United States trustee, continues to operate as a debtor and debtor in possession with all reporting requirements. Most substantially, the debtor, the parishes, and the committee continue in the mediation. Since we've last met, we've had 4 in-person mediation sessions, June 3rd, July 2nd, August 7th, and September 11th. We have an in-person mediation session tomorrow with all hands, except for the committee members and except for the bishop. In connection with our going forward mediations, we're going to have all hands, including all the lawyers, which we think will be efficient and effective for all of us. We continue with our current mediators, retired Superior Court Judge Dan Buckley and Paul Finn. And of course, Catholic Mutual Group is actively involved in those mediation sessions, and I should have mentioned such. And of course, with Everett Seigel and Mr. Oligmuller, who we see in court today. As part of that process and in general, we continue to engage in informal discovery with the committee. We commenced our informal discovery pre-petition, provided substantial documentation to the Zalkin Law Firm, and at that time, KTBS was representing the Zalkin Law Firm, not the committee. They since have moved into committee representation post-petition. We have recently received a broad, wide-ranging informal request for documents covering some 109 categories with many, many subparts. It's substantially broad and far-reaching. The committee's position is they assert they need the information. Our position is they need information, and we are working through the scope and the timing of that process. We have a bit of a disagreement as to how the process has been going to date and on a going forward basis, but nonetheless, that's something substantial that we're working on, is providing documentation to the committee as well as the parishes. There have been substantial requests to the parishes and then other non-debtor, non-parish Catholic entities. So we'll continue to work that through. Additionally, what's significant is that the debtor has worked through the various proofs of claims that have been filed and intends to file claims objections in the near term. We had hoped to have some of those objections on file by now. We haven't gotten there, but we expect within the next couple of weeks, we'll start seeing some claims objections to certain of the claims.
We're being out of time, is that the general point?
Pardon me, Your Honor?
We're being out of time.
Yes, there's a number of categories, but that's one of them. Yes, generally issues that this court can address, in various degrees of scrutiny. Certainly recall we had a discussion relative to setting the claims bar date regarding the voluntary or mandatory supplement. This court ordered, appropriate with the law, voluntary supplements, and there's been substantial compliance with that. There's just a handful that haven't submitted their supplements. But yes, time-barred claims, et cetera, are the things that we'll see. We still have some 487 claims, and we'll see where we end up once we get the claims objections on file. Otherwise, Your Honor, we continue forward in the mediation. As I've said before, many times it's a process. It's taken quite a while. It'll continue to take time, it seems, based on where we are. It seems that we're in, I suppose, a similar position with the other dioceses, at least in California. There has not been any settlement announced in any of those cases. There's different activities going on in different cases. My view is these cases are all different and should be treated differently, as I talked about in the relief stay hearing, but in some ways they're similar. And we'll see what happens with Oakland. I know there was a motion to dismiss the bankruptcy case filed by the debtor in Oakland based upon apparently their inability to reach a settlement and the dramatically increasing administrative fees, which are either approaching or now exceeding $40 million. In our case, we're seeing significant fees being incurred. We are very concerned about that, we as the debtor, and we're concerned because that is money that certainly can be spent for survivors, and we are certainly hoping and not wanting to see this case turn into a litigation case for the purposes of litigating. The committee has its duties, we understand that. Not at all shortchanging those, but we want to make sure that we keep an eye ultimately on the mediation ball. And even if we're not there yet, we have every hope and anticipation we will be, but it's going to be a process. So that's really the update, discovery. I should say there's one more significant update, Your Honor. The diocese owns and schedules real estate for the Holy Cross Cemetery. That's scheduled on its schedules. Fee title is held by the RCBSD. The business operations, however, were not scheduled. Those are being operated by Holy Cross Cemetery and Memorial, an unincorporated association. There is the existing Holy Cross Cemetery south of us here, and there is new property that was purchased by Holy Cross in 2015 up in North County. The intention is for that to be the North County Cemetery named Good Shepherd. And there was to be a consecration of that cemetery as, I think we just, oh, here we go. Let me move forward. There was to be a consecration of Good Shepherd November 24th. The committee requested that we push off the consecration and we push off any existing improvements to the property while we discuss whether or not this is an unincorporated association, independent and distinct from the diocese, or should be rolled into the diocese. We have a disagreement as to that issue now. It's an emerging issue. We have agreed, as I indicated, the debtor, to hold the consecration in abeyance, to reschedule it, and we've agreed to hold off on any further improvements to Good Shepherd while we discuss the issues. We've provided certain documentation to the committee at their request, and there's additional documents to be provided. During the mediation, without breaching the confidence of the mediation and the privilege, we'll have discussions in that regard, as well as the documents tomorrow. So I suppose the document production requests and the Holy Cross Good Shepherd, along with, of course, the important and central focus, the mediation, are the updates for the court.
All right, thank you. Let me ask, the UST being obliged to step back because of the lapse in federal funding, is that affecting anything in any negative way from the debtor's perspective?
Not at all. We've had just a couple of communications from Ms. Raphael relative to the fee applications that have been filed, but it's not affecting us at all. We've worked cooperatively with the U.S. trustee, and certainly they're discharging their oversight responsibilities, but have not had significant day-to-day activity in the case.
But you're aware of them still working, carrying out their statutory duties?
I believe they are, yes. Yeah, absolutely.
Okay, very good.
I don't have any information to the contrary.
No, I'm not, and I'm certainly not suggesting otherwise. They don't come to court anymore, and now it hasn't been entirely clear to the court how active they are in the background. I presume that they're, there's some court set of functions that they're having to execute still.
I would think so, and I've seen that relative to our fee applications. As I just indicated, we had some communications, and in the ordinary course of our case, the U.S. trustee is active when the U.S. trustee needs to be active, but we haven't had substantial involvement with the U.S. trustee day-to-day in general. Yeah. So I believe they are exercising their statutory duties.
All right, thank you. Thank you for that.
Thank you, Your Honor.
Would any other counsel like to weigh in connection with case status generally? Mr. Kidder.
Thank you, Your Honor. Sam Kidder on behalf of the committee. Just briefly on discovery, suffice it to say the committee disagrees with Mr. Caudry's characterization of the informal discovery process as being effective and sufficient. The volume and scope of the production to date has been meager for a case of this size and complexity. That said, we have been meeting and conferring in writing and via Zoom, and we are continuing to meet and confer in an effort to narrow the scope of the disputed issues. So there's no live issue before the court at this time, but there may be soon.
I appreciate being made aware that that pot on the cooktop is bubbling slightly. Okay.
And then on the cemetery development, Your Honor, the committee learned via public news releases a couple weeks ago of this planned consecration. The debtor did not tell us, did not inform the court. Our view is that both the land and the resources that will be used to develop the cemetery are estate assets, and the development, the pouring of those assets into the new cemetery is an outside the ordinary course use of those assets that requires court approval. And so we were very surprised to learn that the debtor planned to move forward with it without court approval. But that said, we have reached effectively a standstill while we evaluate the debtor's claim as to the separateness of the Holy Cross entity and other related issues.
So that amounts to a temporary hold for the moment, essentially. Okay, I understand.
Exactly. Thank you, Your Honor.
Very good, thank you. Anyone else? Mr. Seigel, please.
Your Honor, just on status, and for the record, Everett Seigel on behalf of the Catholic Mutual Relief Society and Catholic Mutual Relief Insurance Company. I believe Mr. Quadri cleared this up, but I want the record to be absolutely clear. Catholic Mutual is a full participant in the mediation, has been, and is continuing to be. And Mr. Oleg Mueller, who is in court, did not travel here for this hearing. He's here for the mediation. He's an officer of the company. And I just wanted the record to be clear that we are participating in the mediation. He initially had forgot to mention that we were participating in the mediation. I just wanted to make sure the court understood that.
All right, very good. Thank you for that clarification. All right. Seeing no other interest to speak to status at this point, let's, before we sort of code shift to the attorney's fees motion, about how far out should we go? Are there natural breaking points time-wise? I don't know how many sessions are scheduled. It's the very end of October. Are we comfortable going into the new year at this point, absent some motion arising? Mr. Quadri, what's your view?
I think so, Your Honor. We have, I may not have mentioned, we also have a scheduled mediation of all parties December 10th.
Okay.
And so I would suggest into the new year, we can get through these issues the last quarter. We know how the last quarter goes. Sometimes there can be a bit of a slowdown. Here we have a lot of activity going on, including an all-hands mediation on December 10th.
Is there a session set for January yet?
Not yet. And we expect that either at this next session, October 28th, we'll open up our calendars and start looking at the new year.
Okay. Realistically, in the last week of December and the very beginning of January, there's not a lot going on. So I'm not sure that the very start of January is a meaningful date. Why don't I hear a little more and then we'll see. In general, for convenience and expense of travel, is there any? It wouldn't affect you, Mr. Quadri. Is there anything like a consensus preference for a Friday hearing as opposed to a Monday hearing? Does that help in any way? Or perhaps it's easier to have weekend days to travel. Mr. Seigel, do you have a view on that at all as I'm contemplating a continuance date for January?
Your Honor, on status, I don't know that I'm necessarily a critical party for status. I think.
But you always come here, and you stood up when I asked the question. That's why I invited you.
Well, I'm usually here because the statuses are connected to mediation dates, or there may be a contested matter. But if there's a status that is just a status, I don't necessarily think that I would be here in person. But if usually a motion gets tacked onto the status. If you wanted to do them on Fridays, that's fine with me. I would do whatever the court wants.
Okay,
so,
I'm not hearing
yeah.
that there's any preference one way or the other. It doesn't make any difference. Okay, thank you for that. Then why don't we go ahead and shift? I guess, Mr. Seigel, you shouldn't wander too far unless Mr. Wong is going to be doing the arguing on the motion.
I am going to argue, Your Honor.
Okay. And I have been through your papers, of course. I understand the arguments. I know well the history and the sequence of it. If there are any sort of marshalling points you'd like to make or anything you want to add in oral argument, and then we'll hear from the respondent.
Your Honor, I have maybe about 5 to 7 minutes of argument that I wanted to make, if Your Honor would indulge me.
Please do.
All right, thank you, Your Honor. We're here on Catholic Mutual's motion for attorney's fees in connection with the Zalkin claimant's withdrawal of their motion to dismiss. The motion to dismiss lacked merit, was highly inflammatory, was filed for improper tactical reasons, and was withdrawn at the 11th hour before the court could decide it on the merits. We have learned through briefing that it was likely withdrawn at the request of the Unsecured Creditors Committee. At least that's a logical and reasonable conclusion from the briefing. The motion to dismiss with the exhibits was close to 1,000 pages long. It multiplied the proceedings in this case unreasonably and vexatiously. Now, this is somewhat of an extraordinary request for fees. But the motion to dismiss and its timing of the filing, its sudden and abrupt withdrawal after the court twice said that it was willing to resolve it, and the completely incredible and indeed some farcical reasons offered by the Zalkin claimants for its withdrawal all lead to the simple conclusion that it was filed for inappropriate reasons, motivated by obduracy or malfidais, and was an abusive process. Because of this, Your Honor, the court has the power and authority under 105 of the Bankruptcy Code, as well as its own inherent authority to award Catholic Mutual its fees. Now, I think what's important is the court should look at this in the context of what was happening at the time that this motion was filed. The court will recall that the Unsecured Creditors Committee on May 5th had moved to lift the stay on certain cases. That was document entry 568. That was fully briefed and set for argument before Your Honor on July 14th, 2025. Now, before that hearing on the lift stay on July 3rd, the Zalkin claimants twice filed their motion to dismiss this case in its entirety, and those are found at docket entry 742 and 743. The Zalkin claimants also had reserved a hearing date of July 31st, 2025. Now, the local rules require that a notice of motion be served within 28 days. The Zalkin claimants, however, didn't file that notice of motion until July 7th, technically not within the 28 days.
You mean it had been filed, but you didn't get a separate paper that said notice?
That's correct, and Mr. Quadri raised that on July 14th before Your Honor.
Meaning that it wasn't calendared, so you didn't have a target date by which you needed to complete your analysis and writing?
That's correct, and Your Honor, exercising his sound discretion, said that's not a big deal. We're going to proceed on the 31st, thereby resolving that issue on the 14th. So the local rule issue, the 9013-6A1 issue, that was resolved by Your Honor on the 14th on the record pretty clearly. Now, as I mentioned, that motion to dismiss was close to 1,000 pages. Now, also on the 14th, Your Honor set a briefing schedule. And Your Honor set a schedule for anyone who wanted to object to that motion to file their response by July 20th, which happened to be a Sunday. No one on the other side of this motion complained, objected, asked for clarification. People just went forward with their obligations and started drafting responses. Now, this motion that was filed started off by rehashing the 2007 bankruptcy, by basically dragging the diocese through the mud of what happened in 2007. Then it went through and alleged essentially a conspiracy between the diocese and Catholic Mutual, and then it alleged that the diocese was not in financial distress, that it was using the bankruptcy to gain a tactical advantage, it was using it as a weapon, and that it engaged in certain pre-petition conduct to shield its assets. Now, one could conclude that perhaps this was filed for reasons other than a ruling on the merits, to perhaps poison the well before the court was going to rule on the lift stay, perhaps as part of a media strategy, who knows? But one thing is absolutely clear. It was an aggressive motion brought at an unprecedented time in this case, very early on. Now, the committee has filed a brief in support of this motion to dismiss, which is kind of remarkable in and of itself. And they do cite that in two other Catholic bankruptcies, I believe Rockville Center and in New Orleans, some individual plaintiffs, state court lawyers have filed motions to dismiss. That has happened very late in the process, not within the first year of the bankruptcy. In our opinion, Your Honor, we humbly submit that this was very early in the process and unprecedented to suggest that the entire case be dismissed, especially while there was this motion pending before Your Honor, before the argument, to lift a stay on certain cases. This was especially troubling given the fact that Mr. Zalkin sits as liaison counsel in the JCCP. Now, this motion, if it granted, potentially would work to the prejudice of a number of state court lawyers and their clients who are sitting with claims without potential coverage, whereas those clients who Mr. Zalkin believes, his clients, who he believes has purportedly more insurance coverage. So this raises all kinds of complicated issues and difficult issues if this motion had been granted. But what it does highlight is it highlighted the material conflict of interest between the Zalkin claimants and the committee. And that was an issue that I raised during the July 14th hearing, and the court acknowledged it during that hearing, and this is at DE 856-2, lines 81, 23 through 25. Now, what we found out, which I think was a little remarkable, is in response to the motion for fees, Mr. Story filed a declaration. And this is at DE 856-1. And what we've learned for the first time, because this wasn't mentioned when the motion for continuance was filed by the Zalkin claimants, is that, and this is in paragraph 3, it was at the request of the committee, this is a quote, at the request of the committee, the Zalkin claimants filed a motion seeking to continue the hearing on the motion. Now, when that motion for a continuance was filed, the ex parte motion, which is 764, the Zalkin claimants said, this is a quote, the Zalkin claimants noticed this motion to dismiss to be heard on July 31, 2025. However, due to scheduling considerations in this case and to afford adequate time for the parties to analyze and brief the issues raised in the motion to dismiss, the Zalkin claimants now respectfully request the court to enter an order substantially in the form of Exhibit A. There's no mention in the ex parte motion that it was at the request of the committee. Your Honor, I submit that the logical conclusion is that the reason that the committee wanted this motion continued is because if they had to file a brief, they would have had to come out against this motion. They would have had to come out against this motion before Your Honor ruled on the lift stay. Now, Your Honor ruled, and what Your Honor said in his ruling, after Catholic Mutual had objected, and this is DE docket entry 773, no other party has requested more time. That was Your Honor's understanding of the situation based on what the Zalkin claimants told Your Honor. You had no reason to believe, based on the record before you, that anybody else wanted a continuance at this time, because that's what the Zalkin claimants told you. Your Honor also denied that request because there was a lack of good cause for it. And you said, we're going to proceed, and you allowed the objectors an additional day because their response was due on a Sunday.
That was an accident that was said on a Sunday. I don't know how that happened. But.
Either way.
And that was actually a Monday deadline anyway.
Yes.
Right. But the way, just the generic, rule of time.
Either way, Catholic Mutual's brief was substantively done at that point because of commitments that we had over the weekend. Now, because the court denied that request, the Zalkin claimant's motion was on a collision course with the ruling on the merits. So what did they do? They took it upon themselves to just withdraw it, and that was DE 776. So in complete disregard to Your Honor's ruling that you were prepared to decide this. And you had already said that you would have decided it on July 14th. So twice you've already said you were going to decide it. They pulled out the rug from under the court and from Catholic Mutual and the debtor and everyone else in this case. Now, had the Zalkin claimants truly believed that this motion had any merit, and if it had been filed for a proper purpose, they would have proceeded. Instead, they purportedly withdrew it under Federal Rule of Procedure 41A. And the fact that they withdrew it at all, I think, is the proof that it was frivolous and filed for improper purposes. Now, in response to Catholic Mutual's motion for fees, the Zalkin claimants make essentially two arguments, Your Honor, two substantive arguments. They say they really, really wanted to proceed with the motion on the merits, and it's not frivolous, but they had to withdraw it, that their hands were tied. They had to withdraw it at the 11th hour, despite what the court did on the motion for continuance. And the first excuse that they offer is that, and I'm going to quote from their brief, and this is DE 856, and this is on page 1. They said they had to withdraw it to avoid a distracting potential procedural infirmity argument related to their notice of motion. Now, you and I have already just discussed this. That's this local rule 28-day notice of motion issue. Your Honor had resolved that completely on the 14th of July. Your Honor also resolved that when they moved for a continuance. Their continuance where they said, continue it to September 30th or sometime thereafter. And you said, no, there's no good cause. And what's interesting about that is Catholic Mutual objected, and no one else joined. So if anybody had an issue with a procedural infirmity and they didn't join that motion for continuance, they waived it. So the notion that they had to withdraw this motion because of procedural infirmity just doesn't hold water, Your Honor. That's an after-the-fact excuse that just doesn't fly. In fact, I think it's specious. And that leads directly to the next argument raised by the Zalkin claimants, which is also found in their response, DE 856 on page 1. And they say, for the first time, and this is a quote, every interested party to the bankruptcy other than CMG expressed a desire for additional time to respond to the motion. Why wasn't that told to the court when they filed their ex parte? We've also talked about that issue. The court specifically found when it denied the ex parte that no other party had requested more time. You would think that if every other interested party to the bankruptcy expressed a desire for more time, this would have been an agreed motion, or there would have been affidavits, or some kind of support for the motion for continuance. That wasn't there. I think that's completely and utterly without foundation, Your Honor, and it should be stricken. And I'll direct Your Honor to footnote 3 in our reply brief regarding assertions that are not supported by any fact, documents, or affidavits. If that was true, other people would have signed on. They would have told Your Honor. Why weren't those communications attached to the story affidavit other than just 2 emails from counsel for the parishes, which occurred after the continuance was denied? Completely irrelevant to this situation. And by the way, are we to believe that the Zalkin claimants would withdraw a meritorious motion to accommodate one of the 2 lawyers for the parishes because of a personal scheduling issue, when the stakes are so high in this case, that's simply preposterous. Now, what is clear is that this motion was filed for improper purposes, whatever they may have been. The Zalkin claimants feel that the motion served its purposes, and they simply moved on, wasting the court's time, Catholic Mutual's time, the debtor's time. You've heard Mr. Caudry talk about his concern over the administrative fees, what's going on in Oakland. Now, Catholic Mutual isn't asking for a lot of money, and Your Honor has the authority to award those fees from counsel, not the individual claimants. But there should be some accountability when lawyers use the court for tactical purposes. And with that, we'd ask you to grant our motion. Thank you.
So the standard in the Ninth Circuit under Section 105 is bad faith, right? So if you point to what you're asserting is frivolousness and improper purpose and gamesmanship and trying to, poison the well, all those things, does that equal bad faith? That's where the rubber meets the road on this analysis.
That's correct. And bad faith is difficult to define. I think you would define it as lack of good faith, Your Honor, and I think the evidence is overwhelming in that regard.
And you think it meets the circuit standard for that?
I think so, and if you wanted additional briefing just on that point, we'd be happy to do it.
There wasn't a Rule 11 motion at any point, was there?
No, there wasn't, Your Honor. Rule 11 would, there's a safe harbor on Rule 11, and that's a more complicated issue, and so, but I don't think that's necessary in this case.
I'm not saying it was necessary, and that it has a soft underbelly, doesn't it? Because you have to go to the effort of opposing the thing and saying, look, here would be the opposition, you better withdraw this.
Right.
So it doesn't, in the end, you're left wondering a little bit what you accomplish there, and you can run out of time doing that as well.
Right.
But the levying of sanctions under that subspecies of Rule 11, much more straightforward than satisfying, what the circuit's defined as the standard for Section 105.
Right.
Okay, very good.
Thank you, Your Honor. I appreciate your entertaining the motion and listening to me.
Thank you. Mr. Story, I appreciate some of that was in the nature of a further response to your opposition, but I'm happy to hear anything that you want to respond to that he just said, or more broadly, but I don't need a systematic rendition of the arguments that are already in writing.
And I won't give you one, Your Honor. So I will respond to some of those points, but I'd like to start with the sort of statutory basis for this request, right, in the circumstances. We've got a motion filed, and we've got a motion withdrawn as permitted by Federal Rule of Civil Procedure 41. So when you look at Federal Rule of Civil Procedure 41, it tells you when costs may be available. And under 41D, it says very specifically, if the motion is refiled, and then Catholic Mutual can bring a request for its costs in connection with the first filing and withdrawal. That's not where we are yet, right? So 41 is clear that there's a process for obtaining costs, and it's when the next filing occurs, not the first withdrawal.
Rule 41 also talks about, this is a motion, it's in the 7,000 series, so this is about adversary proceedings and dismissals of actions.
So
it's not, a motion is not an action, usually.
So here it is, Your Honor. So under Rule of Bankruptcy Procedure 1017 F1, a motion to dismiss must be brought pursuant to 9014. So it's a contested matter. So then contested matters 9014 says specifically that we're going to apply, under this rule, a court order provides otherwise, the following rules apply in a contested matter, 7014. 7014 specifically talks about Rule 41. So it's an ineluctable set of rules that apply Rule 41 to this motion to dismiss. So I understand the argument about 105 and bad faith, but here we have a very clear statutory predicate that we look at 41, and that under 41D, costs are only available at the time of a subsequent refiling.
Okay, I understand.
Okay. So, second, this will go directly to Mr. Seigel's comments. There was some discussion about what evidence is and is not before the court. And I would point out that all of the arguments, every single argument that CMG made regarding bad faith is not supported by any evidence before the court. The idea that there was some nefarious purpose to the filing or some nefarious purpose to the withdrawal, all of it is speculation by CMJ. They had the opportunity, the way they noticed this, they had the opportunity to get our opposition to this motion and conduct discovery before this hearing. But they didn't. They didn't seek to support any of those theories about why this was in bad faith. And I think the reason they didn't is because they saw exactly what happened. They saw that after this court declined to continue the hearing on this, we had a request from Mr. Leeds asking for more time. Would you be willing to withdraw the motion without prejudice as a professional courtesy? Right? I think that's pretty stark in terms of why we withdrew the motion. It wasn't some nefarious, attempt to cause CMG to spend money. It was a professional courtesy to another party in this case. And in terms of there having been a request from every other person, other than every other constituency, for more time, right? Doc 771, right? That was the diocese's response to our request to continue the hearing. They laid out a proposed briefing schedule that was going to give more time. And in retrospect, right, when we went back and we looked at the diocese's bills in this case, there was a billing entry for reading the motion to dismiss, but 0 billing entries for an opposition or for research or anything else related to an opposition. It's pretty clear that Mr. Leeds beat them to the punch in asking if we would withdraw the motion, but the diocese also hadn't done any work preparing an opposition, and time was getting short.
Before you move on, so Mr. Seigel read out part of a declaration saying that the committee was interested in seeing the motion withdrawn.
No, the committee was interested in seeing the hearing date continued.
And not a withdrawal.
That's correct. We didn't have communications with.
Mr. Seigel's firm. So it wasn't just Mr. Leeds' firm that was seeking a continuance, but there were others, and that wasn't put into the application. Onto that.
That's correct, Your Honor. It wasn't in the application. I'm not a bankruptcy practitioner, and I didn't realize it needed to be. I thought that what we had done was sufficient, in terms of putting forward the request for additional time, particularly when the diocese chimed in, the debtor chimed in and explained that, had a different briefing schedule that it had proposed, requesting additional time. I thought that was sufficient, Your Honor.
Okay, I understand.
Devin, it does say allowing adequate time for the parties in the ex parte.
In the ex parte motion, we did say that, however, due to scheduling considerations in this case and to afford adequate time for the parties to analyze and brief the issue. So at least that was broad enough to suggest that it wasn't just, for us. The reality is this was something that, After the fact, we learned Mr. Leeds needed more time for, and that's why we withdrew it. And we had communications with the committee suggesting that they needed more time. So I think the argument is straightforward that everybody in some capacity or another, except for Catholic Mutual, had requested additional time to respond to this. So our view on this, Your Honor, is that there's no statutory basis under Rule 41 for these sanctions. And these circumstances expressly don't meet the requirement for, or the circumstances that could result in an award of costs under Rule 41. With respect to Rule 105, which was Catholic Mutual's other basis, they don't have any evidence whatsoever. They have the opportunity to go get it, but they don't have any evidence whatsoever that rises to the level of bad faith or even close. I mean, the court asked the question, do the circumstances as hypothesized by Catholic Mutual even rise to the level of bad faith under 105? And when you take the hypothesis out of it and look at the record before the court, there's no evidence of bad faith. There's evidence of one party offering a professional courtesy to another one. Your Honor, I'll touch briefly on the notion that this was a meritless motion. And I think to some extent, Mr. Seigel's comments, they go to that. I mean, they just prove that. Maybe they were the comments during the status conference, but he referenced the fact that there are these other motions to dismiss. We saw it in Rockville Center. We saw it in New Orleans. We saw the debtor bring a motion to dismiss that's being heard Wednesday in Oakland. You know, and Judge Lafferty's made comments from the bench. Some cases aren't right for bankruptcy, right? And against that backdrop, there's a bigger question about whether bankruptcy courts are an appropriate place for mass tort claimants to come when they're facing a volume of cases, but before any judgments have been entered. Right? There's the LTL case out of the 10th Circuit, dismissing. There's the Best Wall case out of the 3rd Circuit, not dismissing. Right? There's a difference of opinion on it. There's nothing frivolous about bringing the motion and believing that this isn't the right place for this diocese at this time. So it's not a frivolous motion. The withdrawal wasn't in any bad faith. There's no statutory basis for the sanctions to be awarded. Your Honor, we would ask that the court reject this motion.
Thank you. A couple of questions.
Of course.
So the motion was filed with no notice of motion. It was just out there on the docket. And that is partly responsible for creating the time crunch because counsel didn't know when it was going to have to respond. And Mr. Seigel had argument about that. Do you want to respond to those points? And while you're doing so, explain why you wouldn't have secured a date. I think the local rules talk about securing a date when you want a motion, if it's a type of motion that needs to have a date.
We secured a date, Your Honor, with the court before filing the motion.
There was no notice of motion.
There was a procedural issue with the filing in my office, but we had secured a date from the court in advance before we filed.
Okay, that's never transparent on the docket, right? That's actually an internal, we have a calendaring program. I'll say, facility, and we have tentative holds for dates. Okay, all right, and so as to your argument on meritlessness, is that inviting the court to analyze whether the motion would ever have been dismissed? So would we say, ever been granted? So if the motion was fated to be denied, does that mean it was meritless?
I'm not inviting an analysis of that, Your Honor, but no, the fact that a motion might have been denied by this court doesn't mean that it's meritless, right? Because another court could have granted it, and we've seen...
Meritorious, right?
Yes, Your Honor. It's different than meritorious, right? You know, you could file a good motion, right? And one that you bring to the court's attention and the court hears argument and the court rules against you. Just because that particular judge doesn't see it your way doesn't mean that the motion was meritless and shouldn't have been filed, right? A losing motion can be, better than meritless,
Colorable,
right?
we would say.
Yes, colorable.
I see that. I see that distinction. What about the point that it was brought so early, in contrast to other cases where you referred to different judges might rule different ways depending on what the underlying facts are.
A couple things on that. So one, largely we view the East Coast bankruptcies in these diocese cases as cautionary tales, right? They're diocese bankruptcies that have lasted 3, 4, 5 years. We don't want that here, right? So we get into a mediation, and I know the court has a picture of it from the stay relief motion, but there were more than a dozen mediation sessions before bankruptcy got filed, right? Then we get into bankruptcy, we have more mediation sessions, and it seems that we're bogged, and something needs to be done to help us make progress, right? And that's why an early filing here. It was really trying to get us out of a situation where we didn't think the bankruptcy was working. And frankly, I think you heard from Mr. Cadre today that they don't think the bankruptcy is working, right? That's why they're bringing these claim objections.
Worried. He's concerned when you see the Diocese of Oakland, or is that an archdiocese? I don't know, one or the other. And it's being completely drained with administrative expenses. That was the point, and that's different than saying it's not working.
That wasn't what I was getting at.
Like our work is pointless here, so I'm going to credit you as not saying that.
No, Your Honor, that wasn't actually what I was getting at. It's the claim objections that have been promised in the next couple of weeks, right? And I think you can surmise from the fact that claim objections are being filed, the diocese must also think something needs to change in this dynamic, right? So you're looking at a circumstance where, the parties they've got one way of trying to move things forward, trying to advance the ball toward an end. The committee had a different one with stay relief, and we had another idea, right? But really, it's just three, us, the committee, and the debtor, trying to find a way to move forward, trying to find a way to be productive, right? That's not frivolous or bad faith. That really is just a matter of how do we get to a conclusion.
Okay, I understand. Did I interrupt you at all? Was there another point you were heading toward?
If there was, Your Honor, it's gone.
Okay, if it comes back to you while you're hearing Mr. Seigel again, just let me know. All right, Mr. Seigel, oh yeah, I'm sorry, Mr. Story.
Yes.
I'm sorry, Mr. Kidder. It was.
Oh.
Go ahead.
Thank you, Your Honor. For the record, Sam Kidder on behalf of the committee. Your Honor, the committee filed a brief statement in response to the sanctions motion, and I'd just like to make 4 key points, and I'll be brief, and I think all of these points are directly responsive to CMG's argument and or questions Your Honor has raised. So first, the committee strenuously rejects CMG's suggestion that there's a, quote, material conflict of interest between the Zalkin firm and the committee. Yes, the committee filed a stay relief motion rather than a motion to dismiss. At that time, the committee thought that stay relief was the preferred route to pushing this case toward a global resolution. But that doesn't mean that there is or was a conflict. First of all, on the stay relief motion, the committee and the Zalkin firm were entirely aligned. The Zalkin firm joined the motion. Mr. Zalkin argued at the hearing. And then on the motion to dismiss, there's no conflict there either. The 2 motions are entirely consistent in that both seek the release of cases back to the state court system, and then more generally, both reflect the belief that some significant change, some disruption of the status quo is necessary to move this case forward. So there's no conflict between the 2 motions. There's no conflict between the committee and the Zalkin firm. It's just 2 different procedural paths toward the same overarching goal. Second point, second reason why the committee filed a response to the sanctions motion is that we dispute this assertion that the motion to dismiss was frivolous. And look, Mr. Story did a nice job of sort of reciting the emerging case law in this area. The courts are still grappling with what financial distress means in this context and the motion to dismiss standard. And I understand there are cases going both ways, and obviously CMG has its view as to the merits of the motion. But there's nothing frivolous about the motion, and to suggest that it was so meritless that it could only have been filed to harass just ignores the reality of this case. The reality of the case is, at the time when the motion was filed, the bankruptcy had been going for a year with no progress, and that was after 2 years of pre-petition mediation. And Mr. Zalkin had a front row seat to those negotiations. He knew better than anybody that there was no reasonable likelihood of a consensual deal anytime soon in this case. And under those circumstances, the committee thinks there's certainly nothing improper or frivolous about filing a motion to dismiss. One point as to timing.
Is this your third point?
This relates to a subpart of the motion being a subpoint of the frivolous point. First of all, when a motion to dismiss is based on lack of financial distress, that's largely a pre-petition analysis. It's an analysis as of the filing date. So there's no reason why a claimant should have to wait multiple years to file a motion based on lack of financial distress. And in several of the mass tort cases that we cited, admittedly not diocese cases, but in the Johnson & Johnson talc cases, LTL and Red River, claimants moved to dismiss and were successful within months, and I think in some cases within days of the petition date, based on lack of financial distress. Okay, this is point 3. The committee has an interest in speaking up here because we see this sanctions motion as part of a pattern by CMG of trying to bully and intimidate claimants who speak up and try and move this case forward. As Your Honor will recall, when certain claimants joined the committee's stay relief motion, CMG, in its brief, raised this argument that the only reason the claimants sought stay relief was that their lawyers had litigation financing agreements, and they desperately needed to pay off those litigation financing agreements. And then CMG served discovery to that effect on the claimants who joined the motion. At the hearing on stay relief, CMG never raised the litigation finance agreement, which suggests to me that the purpose of the argument and the discovery may have been to harass and intimidate the claimants who joined the stay relief motion. And then we see this sanctions motion as a continuation of that trend. It's an attempt to punish a claimant or a group of claimants who sought to dismiss the case and break the stalemate. And so the committee thought it was important to stand up and send a message that these type of tactics are not going to chill survivor advocacy and are not appropriate. Okay, fourth and finally, we wanted to respond to the technical Rule 41 point, and Mr. Story covered that very well. Just two nuances there. Number one, the 105A, number one, Your Honor raised the point that Rule 41A speaks of an action, not a motion. Bankruptcy Rule 9002 tells us how to interpret certain rules in the Federal Rules of Civil Procedure in the bankruptcy context. And it says that in the bankruptcy context, an action means a contested matter. So it's black and white here. Rule 41A applies to contested matters. The motion to dismiss was a contested matter. The Zalkin firm was within its rights to withdraw it.
So you're not disagreeing with Mr. Kidder in any way, are you?
I am Mr. Kidder, Your Honor. I'm not disagreeing with Mr. Story, if that's what you're...
I'm sorry. I don't know why I've confused your names twice, because I won't say. So are you saying he sort of set up this logical flow and called it ineluctable, that this is the result? You're not contradicting?
No, I agree with that logical flow, and I'm bolstering that by citing to Rule 9002. Last point, Mr. Story raised the Rule 41D argument. There is a specific, clear protocol for potential imposition of costs in this circumstance. And we know from the Supreme Court's decision in Law v. Siegel that it's not appropriate to use Section 105A, to use the general provision of Section 105A to circumvent more specific statutory provisions. Rule 41 generally lays out how this is supposed to work, and it's not appropriate to look to 105A to get around that. And unless Your Honor has any questions, that's the end of my prepared remarks.
So just so I'm clear, because I think I continue to see a little daylight between you and Mr. Story. So take me through the sequence of rules that makes 9041 apply.
Sure. So Rule 41, I'm sorry, that makes 41 apply?
41.
Yeah. So Rule 41A provides that
Go to the other side of the flow. Where does the rule start? You don't think it starts?
The other side, 9014 provides that one of the adversary rules that applies in contested matters is Rule 7041. And then Rule 7041 incorporates Rule 41. And that's what the Ninth Circuit said in the Alpha L case that's cited in our briefing. Numerous courts have reached the same conclusion. And then if there were any doubt, Rule 9002 confirms it by providing that when the word action is used in the FRCP, it means contested matter in the bankruptcy context.
As a contested petition.
And then,
Not with contested.
if you go down the list, I think the final, I don't have it in front of me, I think the final subpart says any other contested matter.
Okay, I understand that. And the rule in Law v. Siegel, do you think applies to federal rulemaking as opposed to, congressionally enacted statutes?
It's analogous here, Your Honor. When you have a clear basis in the rules or a clear protocol in the rules, I don't think it's appropriate to rely on a more general source of authority.
Okay, I understand. Thank you. Thank you for that.
Thank you.
And Mr. Seigel, would you like to have your final reply?
Thank you, Your Honor. I will be brief. I just have a few points to make in response to Mr. Story and Mr. Kidder. So the Rule 41 point is kind of a technical sideshow point, if you ask me. The real issue is the motion itself. Why was it filed? Why was it withdrawn? Now, Mr. Story talked about 41D allowing for costs. Costs and fees in the federal rules are different. Now, I don't have the federal rules of civil procedure in front of me, so I'm going from memory, and so I will caution Your Honor that this is from memory and not from reading the rules, so I might live to regret this. But generally, my recollection of 41D and the cost issue is the issue associated with dismissing actions and awarding costs associated with refiling complaints, not something, awardable costs under the federal rules, which would be, filing fees. That's not attorney fees. That's something completely separate and apart from this. What we're talking about is the inherent authority of the court to manage its docket, to protect the integrity of the system, as recognized by the Ninth Circuit, as recognized by the inherent authority of the court to deal with vexatious and inappropriately filed motions.
Right. That's a classic. That's the classic connotation of the term.
Yes.
Costs, right. We would need to look at the advisory committee notes on that for when it was first.
So I think Rule 41, we could sit here all day and debate how that may or may not be incorporated into the bankruptcy rules, but that doesn't get to the point. And so, then we get to the argument that Mr. Story made, and we said, well, Catholic Mutual's motion isn't supported by evidence, so I disagree.
Before you move on to that, so we can just so the respondent is saying, well, 7041 applies, and you haven't satisfied 7041D. That's essentially what they're saying, and your position is you haven't moved under 7041 because it would only give costs anyway, which wouldn't be covered by attorney's fees. For our phone participants, can I ask you to please mute your phones? We might be hearing some annoying background noise.
That's correct, Your Honor.
And so then we have the point about Law v. Siegel that we would say, well, now that this is that the advisory committee, whose good work was approved by the Supreme Court and the Judicial Conference of the U.S. and Congress didn't tinker with it, equals a statute for Law v. Siegel.
Yes, and that's getting all very technical. And the other point I would make, and we addressed this in our brief, the cases that they do cite under 41 for the proposition that this would apply to a motion to dismiss, those cases really don't stand for the proposition that they're asserting they do. I mean, I really didn't want to go down this rabbit hole, but
I think
yeah.
it's far enough. I just
Yeah.
wanted to air it while it was out there because we
Yeah.
keep coming back to it. I suppose.
Yes.
Perpetuating that. As well.
And so,
Feel free to move on. Did you want to move on to the argument that I interrupted you on?
yes, and so then Mr. Story chided us for, he said that, we should have taken discovery. That seems a little excessive to spend $100,000 in discovery for a motion that only seeks $86,000 or so dollars in fees. And he says, well, your motion is circumstantial. Well, of course it is. You're proving somebody acting either in bad faith or in lack of good faith. That's how that is proven in the ordinary course. Your Honor has been on the bench a number of years and can look at the conduct and draw reasonable inferences from what was done here. And that's the evidence. The proof, as they say, is in the pudding. The proof is in what was filed, what was not said before, Your Honor, what was said, how it was said, the timing of these filings, and the fact that it was said that, we're going to file this, and they've never refiled this motion. We're told that this was done as a professional courtesy for Mr. Leeds. What's interesting is Mr. Leeds sent an email saying, did you withdraw this because of my schedule? And there never was a response back from Mr. Story saying, yes, we did this as a professional courtesy to you. Where is that email? We're being told that that was the reason for it, but there's no exchange between Mr. Leeds and Mr. Story that would confirm that. There's a question from Mr. Leeds after the motion was withdrawn, asking if that was the reason, and there's silence. But now we're being told that's the case. I submit, Your Honor, you don't have to believe that. Now, the committee counsel says that there was no conflict of interest created by this motion. We respectfully submit that there was. Counsel for the Unsecured Creditors Committee represents every creditor. They have a fiduciary duty to every creditor. As we submitted to Your Honor as an attachment to our motion for fees, the draft brief that we were prepared to file in support of our motion or our objection to the motion to dismiss the case. One of the important aspects of that brief addressed, assuming all things being equal, and there's a lot of caveats to the coverage, but assuming all things being equal, there are a significant number of claims without any coverage, and that is undisputed. There are years where the coverage is just simply exhausted because of aggregate limits, and there are, from 1990 to the current, there are claims where the aggregate limit is $2 million for all those claims. And there are claims that are prior to 1958 where there just simply is no coverage. Not because the coverage is lost or is missing, but because the diocese just didn't purchase any coverage. That was before the existence of any general liability coverage. That committee represents the interests of those claimants just as much as they represent the interests of the Zalkin claimants, just as much as they represent the interests of the claimants that perceive that they have insurance up to $15 million per occurrence. How could they stand here with a straight face and say that there's no conflict if this case is dismissed, where the debtor obviously has limited resources? There would be a significant run on the bank in terms of which of those uninsured claims could actually recover from this debtor.
You're saying that there would have been a huge, that the solution to the collective action problem is lost if you're out of bankruptcy, and you're representing all these claimants. They're not all going to be paid in full. Some are going to get more than others, and that's the conflict. Is that the conflict you're talking about?
That is exactly the conflict, and so that is why we believe there is no way that the committee, had this motion gone forward, could have filed a brief in support of it. Now, there is a lot of background, and maybe Your Honor isn't interested in this. But as I said, Mr. Zalkin was or is the liaison counsel for the JCCP. He has a number of his clients on the committee. The KTBS firm, I believe, was Mr. Zalkin's personal counsel in the Boy Scouts of America bankruptcy. So all those factors, I think, go into this. Now we're told that the motion isn't frivolous, but we're not told what is the response to the argument or what was going to be said in support of the notion that there was collusion between Catholic Mutual and the diocese. Or we're not told why it was relevant to spend page after page going through the 2007 bankruptcy and everything that Judge Adler had said, and how that had any relevance, even to the motion to dismiss. We're not told how they were going to prove up that the diocese was hiding assets or using this as a tactical advantage. All of that is absent from all the pleadings, Your Honor. You could read these, the replies of the committee and of the Zalkin claimants, and you'll see nothing going to what was in that motion to dismiss in terms of how they intended to support those arguments, why those arguments were in the brief, or how those were brought in good faith. Now, they do talk about, well, some cases have been dismissed. Sure, the Johnson & Johnson bankruptcy, which I believe was a Texas two-step for a company that was not bankrupt, was dismissed. What's that got to do with us? And then finally, they say that the committee filed a motion because somehow Catholic Mutual is being a bully. I don't understand that point, but I'll respond to it. There was a motion to lift stay. That became a contested matter. What's interesting about that, Your Honor, is that discovery was served on Catholic Mutual. The committee asked that Catholic Mutual respond on an expedited basis. Catholic Mutual did. Catholic Mutual asked that that be reciprocal on the state court lawyers. They refused. When Your Honor denied the motion, Catholic Mutual stopped seeking the discovery. I don't know how that's being a bully, but that's the assertion. So with that, I will sit down and respectfully ask that Your Honor grant the motion. Thank you.
Okay, thank you for that. Anything further?
Very briefly, Your Honor. It occurs to me that in any bankruptcy case where there are multiple claimants, if you follow Mr. Seigel's reasoning, there could never be a request to dismiss the case because it would create a conflict, at least in theory, potentially, between those two claimants, right? And we know that's not the case. We know that under 1112, you can bring these motions to dismiss for a bad faith bankruptcy filing, right? So they wouldn't have the process of being able to bring a bankruptcy request for dismissal if in every case where there are multiple claimants, the other side could just get up and say, well, there's a conflict, you can't bring that motion, right? I don't think the notion that there's some kind of a conflict here because some plaintiffs may do better in state court than others, it doesn't hold up, right? If the diocese...
Assets to go around to cover all the facial claims, right? I mean, that's the point that it undercuts the collective action benefit, which is one of the three legs of the policy legs of the bankruptcy stool, and that it would be uncomfortable for a committee to argue that, because not all of them are going to, all of the unsecured creditors are going to be paid in full in the state law world. That's his point.
That's not a certainty, right? You have a diocese here, and I didn't want to argue the motion to dismiss, but...
The question of math, isn't it? You look at the facial, I guess in California for personal injury, you can't really specify an amount, but I mean, you could sort of get at that. It's not, it's not, a frivolous argument, I don't think. I would want to see what other courts have to say about that, but it's an explanation that Mr. Seigel is providing for why things happened the way they did.
Sure. Yeah, and the response to it is there are some number of claims that either predate 1956 when the insurance, came in, or fall into a window where coverage was exhausted, right? So there's some number of these cases that don't have coverage. But there's also a diocese with substantial assets that it's listing in its schedules, right? And if it only has to worry about those uncovered cases because the coverage is available for the others, there's really no certainty that anyone's going to come, there's going to be a shortfall with any of the uninsured cases, right? It's hypothetical. Thank you, Your Honor.
I understand. Okay. Very good. Thank you. Mr. Cotter?
Your Honor, just briefly to address a couple of the comments that we heard, and I just want to dispel any thought that I do not think the bankruptcy is working, or the diocese does not think the bankruptcy is working. That's absolutely incorrect and completely contrary to statements I've made before this court and I'm making right now. So we'll clear that out. Secondly, the concept that claims objections are being filed because we need to do something different is not correct. Claims objections are being filed where there's unmeritorious claims, as in every other bankruptcy case. What is surprising is that the committee is not taking that lead and advancing that theory. So we're doing it, and we'll be doing it in conjunction with Catholic.
There was one claim objection earlier, wasn't there?
There actually were two motions to allow late filed claims.
Right.
So, and one of them we did not oppose, looking at the merits of that claim. The second one we have opposed, and that's set for hearing in November.
So your point is that the UCC would, the committee would not want to see late filed claims come in, or any new filed claims come in, because the interests of that it represents on behalf of the existing unsecured creditors will just be diluted.
Yes, Your Honor.
Okay, that's analogous to what a Chapter 13 trustee does, objects to.
Yeah, that's exactly right, and that's the reason claims objections are a typical process in all of Chapter 11 bankruptcy cases. Debtor files them, committee files them. In this case, committee's not taking that lead, and in connection with our mediation, claims are an issue, obviously. So response to bankruptcy is working. We filed it for a meritorious purpose. It allows the creditors in the aggregate to be paid by reaching an ultimate settlement. I've used the word process. I continue to use the word process. It takes some time. It's taking longer than we had hoped, we the debtor. Why had we hoped? Because the longer we're in bankruptcy, the greater there's an erosion of the cash position of the diocese that could be used to pay for creditors. The committee is outpacing us at least 3-to-1 in attorney's fees, and we'll probably see that increase dramatically. That's the reason that I issued that. We all have our work to do. We're doing our work. We have to get to it. The statement that I just heard from Mr. Kidder that there's been 2 years of no progress, completely disagree with. We have a mediation privilege, but that's a positioning in my view. There's no reasonable likelihood of a consensual deal anytime soon. I addressed that in opposition to the motion for relief from stay and was quite distressed that the motion for relief from stay was commenced back in March and April before we'd been to these mediation sessions. So we have a difference of opinion on this. These bankruptcies are here. We're going to get to the end, but we've got to work with the end in mind and not spend our time in unnecessary, expensive motions and litigation practice. I wanted to clear those points up. Last point, no billing entries on the opposition to the motion to dismiss. Let me tell you, we're ready to work through the weekend, and we would have. So I wanted to make those points, Your Honor, and we need to carry on with this bankruptcy. As the court indicated in its order on the relief from stay motion, we need to mediate in good faith with all hands looking to an end. Thank you, Your Honor.
Thank you, Mr. Cowdery. Thank you, counsel, for your arguments. So I'm looking at a date in January, and since Friday dates are not objectionable, January 16, that's a Friday before the MLK holiday, and not seeing any obvious conflicts there. Why don't we do that for status? And Ms. Olivas, if we would do that in the morning, is 10:30 available that day?
Yes, Your Honor.
Okay, so we'll continue to January 16, 2026 at 10:30, and status report 7 days before, as always. All right, thank you. I'll go ahead and note for the minutes as to matter number 19, court heard extensive oral argument, takes the matter under submission, and will issue a written order. As to the status conference matter number 20, continued for further status to January 16, 2026 at 10:30 a.m. Thank you all. That concludes the matter on the afternoon calendar, and court's adjourned. Have a good rest of the day.
Thank you, Your Honor. Your Honor.
Maybe.
You want to talk? You want to go